Mr. Cooper, you have the floor for 5 minutes, please.
Thank you, Mr. Chair. Ms. Verschaeren, the Auditor General's report found that the conflict of interest policy for directors at SDTC did not comply with the SDTC Act. Specifically, it did not comply with respect to Section 12.2 of the Act that states unequivocally that board members shall not profit or gain any income from the foundation. You were the chair of the board. Can you explain how the board adopted and maintained a conflict of interest policy that did not comply with the SDTC Act?
Mr. Chair, I believe that all office holders owe Canadians a commitment to accountability, and I've been accountable. I resigned as the board chair.
Ms. Verschaeren, with the greatest respect, that was not my question. My question is, how is it that the SDTC board had a conflict of interest policy in place that didn't comply with the Act? And here's what this unlawful so-called conflict of interest policy allowed board members to do. And this is right from paragraph 6.46 of the Auditor General's report. Board members were allowed under the policy to buy or sell securities in companies who were funding recipients of SDTC as soon as 3 days after a public announcement of a funding decision. So how was that allowed to stand?
Mr. Chair, those were the procedures. Those are the procedures at the time. And I...
Sharon, here's the situation we have. The SDTC board could approve funding for a company on Monday, and then on Thursday, board members could buy or sell shares in that very same company. Do you know what that is? It's insider trading, isn't it?
Mr. Chair, those processes were in place when I arrived as chair. And so this was the recommendation
they remained in place for 5 years. You were the chair, and for 5 years they remained in place, and you did nothing about it, did you? And Leah Lawrence, the CEO at the time, went to you and said the conflict of interest guidelines or policy as it pertains to the board need to be strengthened, and you kiboshed efforts to strengthen those conflict of interest policies, to bring them in line with the Act and to end the insider trading. Isn't that right?
I followed what I believed and recommended by independent legal advice.
Is that the independent legal advice of the conflicted Ed Vandenberg? Is that the legal advice that you received? Is that your excuse?
And from the management team, that was the way in which
it's very interesting because at SDTC there was a conflict of interest policy for staff. Staff, quite appropriately, were prohibited from investing in a company funded by SDTC for 5 years following a project's completion. 5 years. And yet board members could invest in companies 3 days after a public announcement of a funding decision was made. How do you explain that?
Mr. Chair, the procedures were those that I followed. And
those were ones that facilitated insider trading. And you know what the explanation is? That the board that you chaired was corrupt from top to bottom. And by the way, Ms. Verschaeren, you've sat as a director on publicly traded companies, haven't you?
Yes, I have.
And you know full well that pursuant to the rules on insider trading and self-dealing from the Ontario Securities Commission, that directors can't purchase shares in the company in which they sit as a director on within days of a public announcement. You know that you can't do that, right?
Mr. Chair, I believe that I
asked you, you know that that's not the case. You can't do that.
Mr. Cooper, your time is up. I'm going to allow the witness to answer. So, Ms. Fisher, you have the floor.
Certainly the procedures were established when I got there and continued. And I
One
think
big green gravy train.
I'm going to move on now.
Mr. Cooper,
you're up for 5 minutes, please.
Mr. Chair, despite Mr. Erskine Smith's profound ignorance of the rules of the Ontario Securities Commission, Ms. Verscheren, as someone who served as a director on publicly traded companies, you will be aware that under the rules relating to insider trading and self-dealing, directors cannot buy and sell shares in the company days after a public announcement. Rather, they can only do so during limited windows outside of the quarterly financial reporting periods. And yet, the conflict of interest rules for the SDTC board, which violated the Act, allowed board members to buy and sell securities within 3 days of a funding announcement. I ask you again, why didn't you fix the policy? Because it sure sounds like a good deal for board members.
Mr. Chair, again, I followed the procedures that were established at the time that I joined that board, reviewing these things were the responsibility of management and
so you take no responsibility. Now, I'll ask you this. What constituted a public announcement? Was it just a press release posted on the SDTC website? Is that a public announcement?
Mr. Chair, I don't recall.
Yeah. Well, if Mr. Erskine Smith wants to dispute whether it's technically insider trading or akin to insider trading, it certainly is a racket, it certainly is corruption, and it certainly is a very different standard than the 5 years that staff members at SDTC had to wait before they could do what you permitted yourself to do as a member of the SDTC board. But speaking of law breaking during the time that you were the chair of the SDTC board, your fellow board member, Andre-Lise Matteau, admitted when she appeared before this committee, Ms. Matteau being a very close friend of the Minister of the Environment, Stephen Guilbeault, that the board funneled $10.4 million from SDTC to companies that she had interests in through her investment firm, Cycle Capital. How did you allow that to happen?
Again, Mr. Chair, this was part of the decision-making process in terms of the COVID payments, and
no, Ms. Verscheren, $10.4 million went into companies that Ms. Matteau had an interest in, and these were not COVID-related payments. Ms. Matteau left the room, in fact, when the monies went out the door, but 12.2 of the Act states very clearly, no director shall profit or gain any income or acquire any property from the foundation or its activities. The Act wasn't complied with, just as the conflict of interest policy that you had in place didn't comply with that section of the Act. So again, I put it to you, how did you allow $10.4 million unlawfully to be funneled into Andre-Lise Matteau's companies?
Mr. Chair, the process was the presentations were made to the Project Review Committee. The Project Review Committee would recommend putting them forward. This was a process that I believe, was the same as before I was the chair. So I think it was.
Well, Ms. Verscheren, 12.2 of the Act is pretty clear. I just read it to you. What part of that did you not understand?
Go ahead, Mr. Cooper, ask again.
I asked,
I'll give you time, ask again.
I said section 12.2 of the Act is clear. I read it to you. What part of it did you not understand when $10.4 million was funneled into Andre Lees-Mateau's companies while you were the chair and sat on the board?
As chair,
You have bothered to have acquainted yourself with a very fundamental component of the Act.
Mr. Chair, I certainly recognize, as chair, I felt that I was following all the policies and procedures and conflicts of interest associated with SDTC's.
Well, policies and procedures. Ed Vandenberg, who was providing you counsel, was also being remunerated while he served as a member of the SDTC Council. And while you were the chair, he was voting to appoint 5 members to the board that you were the chair of an improperly constituted council. Did you ask any questions about that?
Mr. Vandenberg provided legal advice and provided service to the SDTC board and to management. And
he was making unlawful appointments to the board while you were the chair. And you just didn't care? You just turned a blind eye to that too? You know, it's conflicts of interest, it's unlawful appointments, it's self-dealing,
Mr. Cooper,
akin to insider trading.
That is your time, Mr. Cooper.
On and on and on it goes.
Mr. Cooper, that is your time. I'm going to turn now